Getting a divorce is one of the most challenging life events that a person can go through. You have built a life together with a person, and for whatever reason, it didn't work out. In the aftermath of a failed relationship, the last thing that you want to think about is how to get a divorce, how to go through all the forms and legal steps required to dissolve your relationship formally in the province of Ontario or in Canada. The divorce is governed by, aptly named, Divorce Act, which is a federal piece of legislation that provides details about the eligibility for the granting of the divorce in Canada. There is basically only one ground for getting divorced in Canada, which is the breakdown of a relationship. The breakdown of a relationship can be evidenced by a number of things. There are generally three categories that are most commonly used to get a divorce, and that are recognized by common law of Canada and the province of Ontario. First, and by far most common, is a separation without the possibility of reconciliation for a period that is not less than 1 year. So if you have separated on January 1st, 2009, the earliest that you would be able to apply for your divorce would be January 1st next year, 2010. It is important to understand that once you apply for divorce, the first stage is actually getting the divorce proceeding a registry form in place with the court office. Only after that formal hurdle has been crossed will you be able to submit the actual divorce application, and in the second stage you will be able to submit your affidavit of divorce as well as any additional documents that the court requires from you. The second ground for being granted a divorce is cruelty. If you can prove that your spouse has been mentally or physically, emotionally cruel or abusive towards you, you do not have to wait for 1 year. These applications based on cruelty should not be made lightly. The accusations are serious, and they have to be supported in an evidence attached to your affidavit of divorce. Also, if you find out that your spouse has been cheating on you, or if you have been cheating on your spouse, you can apply for divorce, or your spouse can apply for divorce on the basis of adultery. Adultery is not the stigma that it once was. There is no scarlet letter that is enshrined in Canadian law. Nevertheless, it does provide for a way to get a quicker divorce without a need to wait for 1 whole year. You do not need to name a person with whom your partner has been cheating on you, but you will need to describe the circumstances that led you to this point, mainly to the breakdown of a relationship. You need to tell the judge the whole story so that they can determine whether you are eligible to apply for the divorce at this point in time. Either with the first or the second stage, you should also provide the court with the original of your marriage certificate. If you do not have your original marriage certificate and there is no way for you to get it, you will have to explain that to the judge in your affidavit for divorce and tell them why it would cause such great hardship to you to get that document. Also, if you've been married outside of Canada and you have the original marriage certificate in a language other than English or French, you will have to provide a certified translation of your marriage certificate. So there is an additional cost associated with this step in the process. Usually, your lawyer will take care of this and you will just reimburse him or her for the cost of the translation. There are two sets of fees currently in place for the divorce proceedings. The first one is paid with the initial application for divorce, and the second one is the set-down fee, so-called, when the judge looks at the final pleadings and just prior to the actual granting of the divorce. Let's assume that you cannot reach your spouse for the purposes of service of the divorce pleadings. If you cannot reach your spouse, you may ask a court to either dispense with the service requirement on your spouse, or to provide for a substituted method of service by either email or advertising or some other method that is likely to bring the pleadings to your spouse's attention. Either way, you will have to make a simple motion before the court, and in many cases you might not even appear before the judge. This is best left to lawyers, as mistakes, whether formal or substantive, can lead to greater delays in your divorce. Once you have been granted a divorce, you cannot get married immediately. You have to wait for 1 month or 31 days after the divorce order has been issued in order to apply for a new marriage license. If you have any more questions, I suggest that you contact your local counsel, or you can always contact us at www.ivansteelelaw.com. Thank you.